Welcome to this presentation of bonding and blocking in guardianships, conservatorships, trusts, and probates. Let's get started. Bonding and blocking are like two peas in a pod. They're tools designed to protect assets and they work in concert with each other. Bonds are commonly ordered for fiduciaries who are managing money. This could be the conservator, trustee, or executor. The bond is a surety that protects the beneficiaries of the estate if the fiduciary doesn't act faithfully or errors are made. A blocked account is sometimes ordered to lock down a financial account. With a blocking order, the bank will only allow withdrawals with a court order telling them how much and to whom and for what purpose. Do you need both? It depends on your situation. You might see 100% of the estate bonded. For example, the conservatorship has a total of $60,000 and they'll consume that whole $60,000 in the upcoming year. They might just get a $60,000 bond for that first year. And 100% blocked, you might see this where you have minor children that are awarded a settlement and they don't need to access the funds whatsoever until the conservatorship is ended. They might block 100%. Sometimes we see a combination. Let's go over that. Here's a hypothetical. Joe has dementia and his daughter Carol is his conservator. He has a trailer for $5,000, a house $400,000, and financial accounts of $80,000. While the house and trailer stay as is, the liquid amount that could disappear, we say, is $80,000, and the court might accept a proposal of $80,000 bond to protect this estate. Let's say there's a plan to sell the house and sell the trailer. Now we've got $485,000 in liquidity. One proposal could be an $80,000 bond to cover the upcoming expenses in the next period, and then put all of the proceeds from the sale into a blocked account. 100% is protected by bond or blocking. Bear in mind that this example assumes that income equals expenses, so no liquidity is building up each month. If you did have liquidity building up, you'd need to account for that in the bond. Well, how do you figure this all out? It can be confusing, and you cannot expect the court to determine this for you. Consult with an attorney who can evaluate your assets, income, your expenses, any upcoming plans or changes, how bondable you are, and that will help them balance the legal fees to unblock and the liquidity needed in this situation. What does it mean to waive bond? In the guardianship conservatorship world, bond and blocking must be addressed if you're managing money. In Washington State, we call the money manager role the conservatorship. And here's a snip from an order setting bond. There are two line items that waive bond. The most common one that we see that you might see is if assets are less than $3,000 and will stay that way. Money in, money out, we say. The other one is if you're a regulated trust company. Let's switch gears. If we're talking about a probate situation where there's a will, the will might state bond is waived. But this usually only applies to the people named in the will and there are no other concerns brought to the court. Where do you get this type of bond? They're called fiduciary bonds. Check with your attorney for some recommendations. The court might have recommendations. You might also be able to find them online. How do you pay for a bond? The bond is usually an expense of the estate. It's not your personal expense. It's typically paid as an annual premium. Here's a snip showing a sample annual premium based on the size of the bond. The bigger the bond, the higher the premium. Some people choose a larger bond so they don't have to go to court and spend legal fees to access blocked funds. It's a balance. What's the process to get a bond? You need a court order setting the bond amount, an application and qualification with the bonding agency, payment for the premium, and then the bond goes back to court to be signed. Be aware that you may need to keep an attorney and record to maintain qualification for the bond. How do you get rid of a bond? This process is called exoneration. This is common if the individual dies, the probate is completed, or there just isn't enough money anymore to warrant it. You can also adjust the bond as needed, and this is something you should bear in mind and monitor all of the time. It involves getting a court order, which you present to the bonding company. Let's switch to blocking. How do you block an account? You need a court order specifying the blocking requirement. You show this order to the bank, who will block the account. Next, you get a blocking receipt, which is filed with the court. And often there's a deadline like 30 days to do all of this. At the bottom, there's a little snip from our state forms database that has a sample form. That was blocking the funds. Now, how do you access them and unblock the funds? You get a court order with the reason and the amount needed. You present this order to the bank, and banks usually want a certified copy of the order. If you're an attorney and you'd like to talk about this, feel free to give me a ring. I love talking with my colleagues. Thank you for watching this presentation of bonding and blocking for fiduciaries. I hope it was helpful. As per usual, consult with an attorney in your jurisdiction for advice specific to your situation. Thank you for watching.